your time for rebuttal.
Yes, Your Honor, if I could reserve 5 minutes.
Will there be one argument or two arguments from this side?
Just one.
Okay. You may proceed.
Okay. May it please the court. Clinton Little from the Knoxville Bar. In this case, I think just a brief timeline will be helpful in examining the developments here. So we have Timberlake Homeowners Association, which is an HOA that was formed in approximately 2000, nonprofit corporation, founded by the developer in this case, the appellee, which is Timberlake Development Corporation. They have a sister company or subsidiary company, Smith-Built LLC. For this case, they were basically one and the same. Smith-Built was added early on in the case when the court brought that to our attention. So from 2000 to 2014, the developer controlled the HOA by appointing members to the board. Then in 2014, the developer transferred that control of the board to the residents of the neighborhood. And so they became in charge of the HOA, if you will.
Now, when was this?
That was approximately 2020, Your Honor.
Okay. Mm-hmm.
And, but in doing that, the developer retained the rights to control the ARC, the Architectural Review Committee, which deals with the aesthetics of lots, the construction of new homes, aesthetics. The intent here is to maintain the property values for the neighborhood as a whole as best they can. So in 2020, the developer came to the HOA and presented a partial assignment of ARC control. So the ARC is a 3-member committee. That's how it's designed, that's how it's formed in the covenants and restrictions. And so what this partial assignment purported to do was assign ARC control for lots that are not owned by the developer or its sister company. It tried to transfer ARC control for non-developer owned lots while simultaneously retaining control of the ARC for developer owned lots. Because of the way the ARC functions, it's a 3-member committee, that effectively created 2 ARCs. If it's a 3-member committee, if the developer retains rights to control the ARC for its lots, but then the HOA has this power to appoint the ARC members for non-developer owned lots, the only rational explanation there is 2 ARCs were created.
Mr. Little, if your client didn't like that, why did they sign off on it?
That's a great question, Your Honor, and had I been consulted ahead of time, maybe we wouldn't be here, but unfortunately, that was done, and here we are. So,
Gotcha.
And so, but in 2021, so shortly before suit was filed, the developer comes back to the HOA with a purported retroactive waiver that says, we disagree with your position, however, we are going to execute this retroactive waiver. We're going to go back in time. And we're going to just exempt us completely from that, which creates another host of legal problems that we didn't really get into in this case. So the HOA filed suit seeking a declaratory judgment. And the HOA asked for the court to declare one of 2 things. So there's alternative relief with regard to the ARC transfer. Either that transfer was applicable to all of the lots or none of the lots. Because the other, the third option there is that it somehow created 2 ARCs. So that's what that's what the HOA was asking the court to simply declare. Was this an all or nothing transaction, or perhaps it was that third option, that there are now 2 ARCs, which will be incongruous with the all of the language in the covenants and restrictions.
So, excuse me, counsel, as I understand, the trial court made a specific determination that the documents in dispute were unambiguous and could be construed and interpreted as a matter of law. Is that correct?
That's correct, Your Honor.
What is your client's position with regard to that?
So in reaching that conclusion, the trial court, and I'll read from the transcript, the trial court said, "I cannot fathom the meaning of a document the way the HOA is trying to interpret it. I just cannot see that the developer would ever do that in their right mind. I can totally understand where the developer is in this argument and why. I understand why the HOA wants to be where it is, because I understand them too. But as a court of equity, the fairness would be, I would give the power to the HOA over the lots that the private sector owns. I think the document retains and the developer wants to retain those authorities over the lots that he owns. I think that's what the documents say. And most importantly, Your Honor, so based upon where I think I would probably end up, Mr. Shipe, if you'll prepare the necessary facts, law, and conclusion, I would appreciate it. So the HOA's position is that the trial court wasn't just interpreting these documents as unambiguous documents as a matter of law. The trial court was trying to get inside the minds of these parties and determine what they might have been thinking, what they might have done or not have done. And the HOA's position is that's well beyond a 12026 motion to dismiss. That's summary judgment territory. And that's what the HOA's argued the whole time is this case needs to be fleshed out, not dismissed on a 12026 motion. The Cannon case, Cannon County Board of Education case, for example, says the fact that a party seeking declaratory relief is not entitled to the judgment sought, meaning it's not going to win at trial perhaps, does not mean that the parties are not entitled to the relief from uncertainty that a declaratory judgment affords. And so what this case is about is, what this appeal is about is, was it proper for the trial court to get inside those minds of the parties and state that the HOA had failed to state a claim upon which relief can be granted? As we know, the trial court is required to accept all the allegations from the plaintiff as true, and then determine that. The closest case that I could find on this, and I believe Mr. Shipe cited to it in the developer's brief, it was an HOA case dealing with covenants and restrictions, but the court found that the lot owners did not have requisite ownership of some lots. Therefore, I would assume that's a standing issue. That's not what we have here. Standing wasn't ever challenged or anything like that. This was simply the HOA is asking for its day in court to flesh out its allegations and seek responses from the developer and perhaps summary judgment if that's where we head. But just not just a 12026 motion. As this court knows, along with a 12026 motion comes the statutory attorney's fees. So we have a situation where the trial court essentially tried to interpret what the parties were thinking and what they may have intended and not intended, and then dismissed the case and is putting the HOA on the hook for attorney's fees simply because this motion to dismiss was granted. And that would be improper. Again, the HOA is simply looking for the court to declare where do these documents leave us so that we can all go about our business and know where those contours may fall. And excuse me, last, the transcript of the trial court is somewhat limited in the scope of its findings and conclusions of law. Mr. Shipe did a great job with the order. It's just that the order, the HOA's position is that order went well beyond the scope of what the court actually pronounced from the bench. The case law is clear on there that Tennessee Supreme Court does not not look favorably on trial courts adopting verbatim those orders. The trial court needs to put its own spin on things. Certainly parties can submit orders, but the trial court needs to take those orders and make it its own. So I see my time is up, so
You have your rebuttal.
thank you.
Yes, sir.
May it please the court. My name is Ed Scheib. I'm here with Avery Lovingfoss, and we represent the appellees in this case, and that is Timberlake Development, LLC, and Smith Built, LLC. From the outset, I think I need to clarify a little bit because although we were prepared to discuss the substance of what happened below, I was a little surprised to hear argument about that from the appellants today because their brief did not in any way address any of these substantive matters. We immediately went to discussing those things, and I'm familiar with those arguments because that's what was made before the trial court. But as we'll discuss briefly in a few minutes, the arguments that were in the appellant's brief were simply procedural arguments as to what happened in the case and did not address the underlying substance of the case. So I will address the substance first because I believe that is what compels this court to affirm the decision. But then I'll address the procedural issues because I believe that the substantive issues are waived by the appellant and that only the procedural issues are before the court today. So I think it's accurate to say what the appellant said in describing the request for relief in this case. The request for relief under the petition was limited to a specific document, and as Judge Davis, you asked, this is the document that the president of the HOA actually signed. And the question presented to the court and the relief requested was, what is the effect of this assignment? Is it all or nothing, as counsel for appellant stated, or is it the ability to create these two different architectural review committees? We agree somewhat that that is the starting point, but that is a snapshot of exactly where this court needs to start and what the issues before this court are, because that makes it a very straightforward issue. And that issue is, what do these documents say and what do they mean? And the two critical documents are in the record. It's R56 through 57, which is the assignment of developers' rights to ARC members. And then the second document is in R58, which is the Architectural Review Committee waiver. So let's look at those two documents because that's the starting point, and that's where this dispute got to why we are in a lawsuit. And ultimately what this is showing is what the developer did, and in fact confirming that this developer did the right and equitable thing. What happened here is that HOA approached the developer asking for control over the Architectural Review Committee. And the developer agreed to an extent because it made sense. And the developer, trying to act fairly to these homeowners, agreed to grant that architectural review control as to those homeowners' lots. They should be able to control architectural review for fences, additions, swimming pools, landscaping, those sorts of things. That makes sense, and that's a fair and equitable thing that this developer did. But to the extent that the developer or its affiliated entity, Smith Built, still retains lots in that neighborhood, which it does, it should be able to control the Architectural Review Committee with regard to those lots. And that's precisely what this document does, which is in 56 through 57. It grants Architectural Review Committee control to the HOA for their lots, but retains it for those lots owned by either Timberlake Development or Smith Built. And in fact, in that document, it says the association hereby accepts such assignment and the rights and powers granted thereunder. And if you look down, and it's in the record, you all can't see it this far, I'm certain, but you can see that this is signed and notarized on behalf of the developer on page 56 of the record. And then critically, on the next page, it is signed and notarized by the president of Timberlake Homeowners Association, Inc. And the notarization language there says that the president executed the foregoing instrument for the purposes therein contained. This document is an unambiguous document, as Judge Frierson, you commented, but also it has an estoppel effect, which all written contracts do, and that's the purpose of having written contracts. When a party has authority and signs name of an entity to a contract, you are then bound by that contract and what it unambiguously says, and this is an open and shut matter about contract interpretation. Now, the second contract was really an effort, an ongoing continuing effort by this developer to try to, yet again, avoid litigation, avoid disputes, and try to avoid being exactly where we are today, which is the Architectural Review Committee waiver. And that's in R58 of the record. And this was simply an exercise of the right to amend that is contained within these covenants and restrictions. And as this court, I'm certain, knows from the Hughes versus New Life case, the Tennessee Supreme Court has said that when a developer retains the right to modify or amend restrictions, that right is enforceable. So in an effort to try to avoid any argument about was the transfer all or nothing, or can there be two arcs, the developer attempted to try to cut this off at the front, explain that this wasn't something that needed to continue, and try to be reasonable and equitable to this board. And that's what they did in the Architectural Review Committee waiver. They exercised the rights they reserved in their covenants and restrictions that the Supreme Court says is enforceable. And they said in here that the Architectural Review Committee provisions do not apply to those lots owned by Timberlake or Smith-Built LLC until such time as they're no longer owned by Timberlake or Smith-Built LLC. So it again creates that same effect that as soon as homeowners are living in these, then they have the ability to control their own residences, their own land, and their own common areas, and this gave them those rights. That's what this dispute is about. And frankly, I think that's the start and finish of this dispute, because basic contract law applies to those. So now, again, the HOA didn't brief any of those issues in the appellate brief. Instead, what they focused on were these non-substantive procedural arguments. And I'll briefly address each one of those to the extent Your Honors have any questions about what I've said or about these. I'm happy to address them. But I think these are pretty straightforward. There's 4 procedural arguments. The first procedural argument that they make is that the trial court failed to take the facts as true from the petition. As everyone in this room well knows, under Rule 12 motion, the court is required to take the facts alleged as true and construe them in favor of the non-movement. But the problem with that argument here is, as we've already discussed what determined the outcome of this case, there are no facts at issue. This is about unambiguous contracts. The first one, in fact, signed by and notarized on behalf of the HOA. So to the extent that this is signed and unambiguous, there's clear Tennessee law saying that's a pure matter of law. There are no facts issues there. So to the extent that the appellant is pointing to supposed facts in the complaint, there are none. And the Tennessee Supreme Court has spoken to that too. It's the Webb versus Nashville Area Habitat for Humanity case. And it says that a court is not required for purposes of Rule 12 to accept as true legal conclusions. So that's the first procedural argument, and it's not meritorious. The second one is that the HOA appellant is arguing that somehow the trial court looked outside of the pleadings and contracts. And we heard a little bit about that from their presentation. But the problem there is that that rule prohibits looking at extraneous evidence, the parole evidence rule, looking outside of the contracts themselves. And there's really only 2 sources of information that the court looked at. Number one, were these 2 documents that are in the record that we've already discussed that were attached as Exhibits 2 and 3 to the complaint. Well, we all know that Rule 10.03 says that anything attached to the complaint is incorporated for all purposes, and the case law establishes that includes motions to dismiss. So that's not the outside material. Instead, what we heard is a transcript of the court's oral ruling that is in the record. I think it's at R106. That's correct, R106. And there the court making the ruling as to who was going to prevail on the motion. And there the court put itself in the shoes of the different parties. But that's entirely appropriate. In fact, that's the issue that was very recently in front of the Tennessee Supreme Court in the individual health care specialist case versus Blue Cross Blue Shield. And they said that there's 3 sources of information that a court should and ought to look for in interpreting a contract. 1 is the 4 corners of the contract. 2 is the circumstances in which the contract was made. 3 is the party's actions in carrying out the contract. So the circumstances one is what the trial court was doing here. Now, you can't look at extraneous material, that's the parole evidence rule. But here, if you're looking at this document, identifies who the parties are, one's a developer, one's an HOA, the court is permitted to look at those and consider those circumstances. That's not extraneous material, so that was not erroneous to consider that material. So that's the second procedural argument. We don't believe that's meritorious either. The third argument that the appellant makes on appeal in their appellate brief is that somehow a motion to dismiss was an inappropriate procedural mechanism here for a declaratory judgment action. And the HOA essentially wants to create this black line rule that motions to dismiss are never permitted under declaratory judgment actions, and that's not what the case law says. And we briefed it in our brief. It's the Cannon County case and the Bedford County Hospital case. And those say, they say it may be unusual. We concede that fact. However, the reason why they say that is because the same rule exists in both those cases. It's this: when one party seeks declaratory judgment as to what are our rights, it is not an appropriate solution to say, we just dismiss it without telling you what the rights are one way or the other. What those cases stand for is the proposition that if a petitioner says, I believe the answer should be A, and the court believes it's the other side, the court needs to issue an order saying it's the other, it's B. And that's exactly what happened here. The order that has been appealed from is an order granting the motion and declaring the rights of the parties. So those cases stand for the proposition that in any outcome following a petition for declaratory judgment, the ruling must include a declaration of those rights, and that's exactly what happened here. So to the extent that the appellant is asking for a black line rule, there is no black line rule like that. This is an appropriate use of a motion to dismiss in a declaratory judgment action because of the same things we've been discussing all along. These are pure matters of law about unambiguous contracts. The last procedural argument that the appellants are making, and we heard a little bit in their oral presentation about this as well, is taking issue with how the order came about. And there's a couple of problems with that, and let me kind of back up to how this happened. And Judge Davis, I know you practiced downstairs from this in Knox County, but in Knox County and many counties across the country, they have a local, or across the state, pardon me, they have a local rule. And that rule creates a procedure as to who drafts orders after the court makes an oral ruling from the bench. And here it's the local Rule 11 from the Knox County Chancery Rules. And what that rule requires is after the court makes an oral ruling, determines for itself what the outcome is going to be, the prevailing party drafts that order, and then within 10 days is required to submit that order, and is directed to make attempts to try to work out an agreement as to form of that order. If the parties cannot reach agreement, then the prevailing party files that order, and then the opposing party then has 5 days to file a competing order, and either the judge decides on one or the other, or there's a hearing, a conference call. In fact, I got an email while I was waiting about a conference call in one of the Knox County courts for that exact purpose today. That's exactly what happened here. We already have the transcript at R106 where the judge announced what the legal determination and ruling was going to be, and then asked for the prevailing party, the appellees here, to draft that order. So there's three issues that come up here that show why this is not a meritorious argument. One is that the appellant, the HOA, did not avail itself of that process. The appellant had an opportunity to file a competing order at the Chancery Court level and failed to do so. And that is a waiver of this argument before this court. And that failure left the trial court unable to make a determination about what was wrong about the proposed order versus what the HOA wanted. But it also has a problem with this court, because this court, there's no presentation from the appellants as to here's what the order really should have said. It's just that how the order came about is the problem. And that kind of circles back to the second problem with this argument, which is the flaw in the appeal brief. There's no substantive argument in the appeal brief, and there's no substantive indication here as to what the order should have said versus what it actually did say. Because ultimately, that order reflected the very same arguments that are in the motions. And as any order says, as probably any order that's been in front of this court, this matter came before the court on this day, and the court considering the filings, the arguments of counsel, hereby rules. The filings are incorporated in any kind of order, and that's what the court considered in making that determination. Now, we don't have the full transcript because the hearing lasted over an hour long, but we do have the ruling part of it, and we do have the briefing, and it reflects all those arguments in that order. The last problem with this is what I've mentioned a few times before, is it's just built upon a false basis, and that is that the court deferred to counsel to make the determination of who should prevail and who should not, and that's just not the case. At R106 is where the transcript is, and we've already heard that read from today from appellant's presentation. The court made a determination that the developer's interpretation was the correct one. And that came from the briefing, and that came from the oral argument. And then, and only then, asked for counsel pursuant to Rule 11 to draft the order reflecting that ruling. So this is not an instance of passing off the entirety of findings of fact, which are the trickier ones of the two, and then conclusions of law to a party to draft on their own. The judge had already made the determination in this case. So this concern about whether it's independent thought, the two-factor rule, that really doesn't come into play here. Now, finally, because I only have a few seconds left, we would ask for an affirmance in full of this case. We also asked for an attorney's fees. I believe because of the nature of the appellant brief that this is a frivolous appeal, so we would ask for our attorney's fees for this appeal, and we've relied upon our brief for that subject. Any questions, Your Honor?
I hear none.
Thank you.
Thank you. Your rebuttal?
Thank you, Your Honor. So, in response, the first thing I would do is note in the the order affirming the trial court's original order of dismissal, the very last paragraph, and this is page 113, I believe, in the technical record. The court says, the order granting motion to dismiss and declaring the rights of the parties dated January 30th, 2023, order is amended as described in this order. So right there, the order granting the motion to dismiss and declaring the rights, I don't think those two can go together. If the case is dismissed, how does the trial court then go beyond that and declare the rights of the parties? And I submit that was an end run around to stick the HOA with attorney's fees under the statute regarding 12026 motions. If that motion is granted, the trial court shall grant attorney's fees. So we have an order that dismisses the case yet declares the rights of the parties. So that's problematic. In the Cannon County Board of Education versus Wade case, the quote there is, the prevailing rule is that when a party seeking a declaratory judgment alleges facts demonstrating the existence of an actual controversy concerning a matter covered by the declaratory judgment statute, the court should not grant a Tennessee Rule of Procedure 12026 motion to dismiss, but instead should proceed to render declaratory judgment as the facts and law require. And that's all the HOA is asking. Don't dismiss the case. Declare what the rights and obligations of the parties are. That's all. And if the HOA loses, then so be it. But a motion to dismiss or an order to dismiss in this case was inappropriate because it is a special species of lawsuit. I'm not saying that a motion to dismiss can ever be granted, as we saw in the HOA case cited by the appellees. A standing issue can certainly have your case dismissed, something like that. But in this case, that's not what happened. In this case, the judge stated from the bench that he just couldn't see it, and most importantly, said, this is where I would probably end up anyway. So I'm just going to go ahead and do it now in a motion to dismiss. So, and as far as the factual allegations in the appellant's brief, quickly, I counted at least 10 that I don't believe are legal conclusions. They're facts. They're factual allegations. Now, some may be position statements on certain things, but certainly not legal conclusions that would, not be taken as true for purposes of a motion to dismiss. So, and just briefly, Your Honors, Mr. Scheit mentioned why the developer may have done things, why the developer may not have done things, what the impetus was behind these things. Again, for a motion to dismiss, it's just inapplicable. Maybe a summary judgment, but again, not a motion to dismiss. So, unless the court has any questions.
I hear none. Thank you very much.
Thank you, Your Honors.
I want to thank both the attorneys for your presentation. Your case has now been submitted to the Court of Appeals. You should receive our opinion and judgment within a reasonable period of time. Thank you very much.
Thank you.
The lawyers may be excused.